My name is Sana.
Oh, Senna.
Yes.
Apekakakakaka.
Meswakpo. Meswakpo. Let's start from, of course, the apology that you rendered on behalf of Chairman Wontumi. Why?
So, thank you for the opportunity. I think that I've been observing a few things around, and I felt that it was important that I stand in on his behalf to send an apology to the first gentleman of the land, his wife, and the family on a personal level before we deal with the legal issues. And I felt that some very discerning Ghanaians, maybe about 15%, who are deciders on who wins an election, believe that the approach I've taken is the right step.
Is your apology in any way connected to his sentencing and the term he's serving in prison?
My apology is connected to events leading to the 2024 general election.
Okay.
And statements that were made.
Okay. And the question is, why now?
The response is, why not now?
Because there are those who are interpreting that to mean that you're suggesting that that may be the reason he's being sentenced. Is that your thinking?
Well, I think that opinions are many, so are men, which is what Shakespeare says. And so they can have their opinions on the interpretation of what I'm stating. But I think that the first gentleman of the land will receive this apology in good faith.
Would it not be reasonable to interpret it in that manner, that you are only apologized only after he's been sentenced? So is your opinion that perhaps the prosecution was personal?
I don't think that that is the issue. And I don't think that that is what I seek to drive at.
I see. And then on the matter of he being in prison, have you been able to go and visit him?
Yes, I have.
How
And
is
he's
he?
doing well. He's fine.
What has he been telling you about the decision of the court?
Well, those are matters that are between us. But definitely, his position is the position what the lawyers have done, which is seeking the appeal.
He insists that he shouldn't have been. Is innocent of the charges brought against him.
Well, the grounds of appeal are five. The first is that the convictions are unreasonable and cannot be supported, having regard to the evidence adduced at the trial. The second is that the learned trial judge did not read the Minerals and Mining Act 2006, Act 703, as amended as a whole. The combined effect of sections 13(8) and 46 of the third act is exculpatory of the first and third appellants and consistent with their innocence. The third is that the learned trial judge usurped the jurisdiction of the Supreme Court in flagrant contravention of Article 1031A and 2 of the Constitution 1992, interpreting Article 1911 of the Constitution set against Sections 14(1), 59, 99, 2B of the Minerals and Mining Act 2006, Act 703, as amended by Section 3 of the Minerals and Mining Act 2019, Act 995, as clear when both parties have rival meanings on the words in parentheses, unless the offense is defined in a written law. The fourth being that the learned trial judge acted in flagrant violation of Article 1301B and 2 of the Constitution 1992 when her ladyship refused to stay the delivery of the judgment and refer the constitutionality of Sections 14(1), 59, 99, 2B of the Minerals and Mining Act 2006, Act 703 as amended by Section 3 of the Minerals and Mining Act 2019, Act 995 to the Supreme Court for determination. And the final grounds of appeal is that the learned trial judge misdirected herself in law when in effect her leadership held that the vagueness and or overbreadth of words employed in panel provision in a statute is a question of statutory construction and not constitutional interpretation, while disregarding the constitutionality of the impound provision of the final statute that were actual vague and overbroad in light of Article 1911 of the Constitution 1992.
Interesting. Okay, so kindly break that down for us, because not all of us can put together the provisions you're talking about and perhaps put those meanings you put in. Exactly what are you saying?
So if you look at the judgment and you look at page 15 of the judgment, it says that consideration of the evidence and the elements of the offenses charged, that the charge sheet contains two main offenses, namely, one, assignment of mineral rights without approval, two, purposefully facilitating an unlicensed mining operation. These are the two offenses. If you come to the third grounds of appeal, it states that the trial judge usurped the jurisdiction of the Supreme Court in flagrant contravention of Article 1301A and 2 of the Constitution 1992 in interpreting Article 1911 of the Constitution set against Sections 14.1, 59, 99, 2B of the Minerals and Mining Act 2006, Act 703, as amended by Section 3 of the Minerals and Mining Act, Act 995, as clear when both parties have rival meanings on the word unless the offense is defined in a written law. Okay? Is that the motion that was moved on the day of the judgment to stay the execution of the judgment, to wait for the Supreme Court's interpretation, was quashed. And so these five grounds of appeal is what the Court of Appeal is going to be looking at. We would give them time. They would get back to us. We would feedback the Ghanaian people. And I'm sure that we would have some good news at the end of the day.
Interesting. On the matter of referral to the Supreme Court, from what I have read and what my colleague was even reading to us this morning, it seems the trial judge is of the opinion that what you are asking, it is not automatic, that she, the judge, has to agree with the issue you are raising. And that is the opinion of the Supreme Court. The Supreme Court says the judge must be convinced that there's a question to be referred to them, there's ambiguity before referring it to the Supreme Court. And she's of the opinion that the provisions in question are clear. What do you say to that?
What I say to that is that we live in a society where we have big brothers. We live in a society where institutions have big brothers. If there is ambiguity, you go to your big brother to settle the matter, which is why we have the Supreme Court. If not, then there's no need to have a Supreme Court. And so one may have an opinion, but we may be able to settle it at the Supreme Court. If you come to chieftaincy, one may have an opinion, but you settle it on the grounds at the King's Palace. When the King makes a statement, it's final. It settles everyone's disagreement, and we all agree because the King has spoken. If the Supreme Court gives an interpretation and it is in line with your opinion, it is the Supreme Court that has won.
So for you still insist that it's a matter that must go to the Supreme Court?
Well, it's not about insisting. It's about making sure that the institutions work. And I think it should be your interest, as it is my interest, and the collective interest of the Ghanaian people, that we have big brothers. Those big brothers must work so that there is no ambiguity.
I see. When did you file this appeal?
Yesterday, in the afternoon around 1:40, it was received by the registrar and the High Court.
What are the next steps for you?
the next steps, the legal break is on Friday. I am not too sure what will happen during the break, whether the Court of Appeal will sit or would have to wait till the break is over and in October. But I know that we would be working on a bill pending the appeal hearing.
Okay. So you're asking for bail pending a hearing?
I'm certain that would be the next step of action.
I see. Well, Paul Grave, thank you very much for speaking to us.
Thank you, Senator, for the opportunity.
Paul Grave Boachi-Dankwa, spokesperson for Chairman Wontumi, join us on the line and explaining. So he says, as for the apology, it has nothing to do with
sentencing of Chairman Wontumi.
Not necessarily. So the events leading to. He says they are not saying that the president is behind the journey.
Enti no chairman ne ka say me bra emepa omampani che won fama na say me bra na hu say e wo say opa che de ma chairman.
No, say you're chairman spokesperson, so everything he says is in the name of.
If I recall,
continue say my boni na say my sena boni. Now I am spokesperson. Me di sena tema ka to sem dia to sena na busuan for so serious man pa. Na me pese amanfo hu say manu me ho a. Wo na be pa che wa ma me na say me na me pese
me your spokesperson. Say me your official spokesperson there bibia make whatever I say to the issue is in your name.
Yo. But emrebe na hu say I was semi pass and
that's the question. That's where the issue is. Because they ought to have rendered this apology long time ago because it's happened long time ago.
And unim say would do be at him say sebi.